Brilliant, and thank you for that hugely enthusiastic start to my session. Much appreciated. I can't believe it's back in 2016, the last time I did one of these updates. And I can see I've got the wrong logo on here on my screen. It should, of course, say Seeker, which will be corrected on the notes. So, yeah, we're looking at 5 years worth of updates in terms of case law. So, a few little bits about the company I work for. I appreciate that lots and lots of you have been on these sessions before. We basically span the engineering and construction industries and give contractual commercial advice across the board. So you can see some very, very pretty pictures there. We are a market leader in expert witness, planning, commercial, technical, importantly, dispute avoidance. And really the point of today is to show you how things have gone wrong for organisations. And hopefully from that, you will then avoid similar disputes yourselves. Of course, if things go wrong, yes, of course, we will be delighted to give you a hand in any dispute resolution issues that you have. Company was established in 1978. We are stock market listed with over 350 staff worldwide. In terms of the spread over the country, you can see there are different offices. I normally work out of our Northwest office in Hooton in Cheshire, but we do have offices around the rest of the UK as well. Three main parts of our business. Left-hand side, we have driver project services, and we can supply staff onto your live projects. So that could be QSs, project managers, or indeed delay and planning staff. I work for Driver Tret, which is in the middle of the chart in front of you, and we work in terms of contract advisory services, commercial and contract management, planning, programming and scheduling, of course, as well as dispute resolution services. Finally, on the right-hand side is our expert witness division, Dialis, and we can provide experts in adjudication, arbitration and litigation, and we also have adjudicators, arbitrators and mediators working within the company as well. How do we help Seeker members and other similar organisations? I always like to start with reminding everybody that normally the answer to a particular issue is contained in your contracts. So making sure that you do the due diligence before you sign the contract and make any contract adjustments to protect yourselves and appropriately allocate the risk between you and the other party is hugely important. Once a job becomes live, obviously we're very happy to look at your notices and applications for payment or payment notices. We often do due diligence on programs to make sure that you're actually putting in place the right information, whether it's to do with COVID or other events. Obviously today we're talking about NEC contracts, so we will be talking about looking at how the compensation event regime works in a number of those. As well as providing health checks and looking at claim situations, obviously we also do training such as today. We produce a regular digest magazine. It's produced twice a year. If you want a copy, please do visit our website, or of course you can ask me or our marketing department for a copy. A little bit about me. I am a quantity surveyor, so normally when I'm doing these Seeker sessions live, I would normally get a boo from a couple of people, but I'm hoping that there's a few QSs on the line as well. Chartered, I'm ex-Balfour Beatty, where I worked as a main contractor's QS for 5 years, and I know that many of you wear that same badge now. I went on and did my law degree and solicitor's exams, and I've been in construction claims consultancy for over 20 years. So as I said, the last time I did an NEC update was back in 2016. And so essentially what I'm going to do is look through some of, I'll say, the more interesting cases that have happened since then. The first one I want to talk about is a case from 2017, which is Costain and Tarmac. Now, slightly unusually, this wasn't a supply and install contract. It was a supply only contract, but actually the parties did use an NEC contract. It was an NEC supply contract, and also there was a NEC framework in place as well. It was all about the supply of concrete for a safety barrier on the M1 motorway. Contract was dated February 2014. terms were on one page, but it was linked to this framework. It turned into a dispute that was worth £6 million. And one of the clauses that the parties were looking at in detail was the time bar clause in 93.3. Now, this particular time bar clause is slightly unusual. It wouldn't be directly applicable to the main contract, as you would know, so the NEC main contract or indeed the NEC subcontract, but it is worth looking at. The time bar clause says at 93.3 brackets 1, a party may refer a dispute to the adjudicator if the party notified the other party of the dispute within 4 weeks of becoming aware of it. Okay. And secondly, between 2 and 4 further weeks have passed since the notification. If a disputed matter is not notified and referred within the time set out in this contract, neither party may subsequently refer it to the adjudicator or the tribunal. Now, a reminder, the tribunal is either arbitration or litigation, and that's stated in the contract data. Of course, everyone knows that under an NEC contract, you must go to adjudication first. And that's what the parties did. They went to adjudication, and it was held in adjudication that Costain were out of time to pursue this £6 million dispute because they had failed to comply with 93.3. In court, where Costain were trying to say, well, actually, no, we don't agree with that adjudicator's decision, they relied on clause 10.1. Now, of course, the version that we are very familiar with in the NEC3 main contract says the employer, contractor, the project manager, and the supervisor shall act as stated in this contract and in a spirit of mutual trust and cooperation. And it's very similar in the NEC supply contract, which states the employer and the supplier shall act as stated in this contract and in a spirit of mutual trust and cooperation. Now, the NEC contracts aren't colour coded in the way that I've done it here, with a part in red and a part in blue. And essentially, what the parties were looking at here is this issue of spirit of mutual trust and cooperation. And how on earth does that fit with the time bar clause? And when the judge was looking at 10.1, he went back to an earlier case back in 2011. The case is F&C Alternative Investments and Barthélemy. And the judge in this case said, it is a form of contractual duty which requires the obliger to have regard to the interests of the obligee, whilst also being entitled to have regard to its own self-interest when acting. Keating on NEC3, one of the big textbooks on this particular form of contract, says, he looks at the second limb, so that was my bit in red, the spirit of mutual trust and cooperation, as allowing the parties to maintain their legitimate commercial interests, but not so that their words and deeds are attempts to improperly exploit the other party. Importantly, it is not a general obligation to act fairly. Now, in court, bearing in mind the resources that the judge had to hand, Coulson decided that clause 10 meant the following: that Tarmac could not lull Costain into believing that the time bar was inoperative. In other words, they couldn't trick the other party. And indeed, there was a positive obligation on Tarmac to correct a false assumption put forward by Costain on the inapplicability of the time bar. And the main question that was looked at here was whether 10.1 on its own required Tarmac to tell Costain about 93.3. And it was decided that it didn't. The judge said, in the present case, I find the defendant did and said nothing about clause 93, which was or could have been misleading, and therefore the time bar stood in this particular case. So it's interesting to look at the interaction between those two clauses, and very much the judge is saying, look, the parties have signed up to a time bar. It's there for a reason, to get certainty at the earliest possible opportunity, and therefore you can't then rely on another clause to try and get out of it. Second case I want to look at today is another 2017 case. And I will say that this particular case has attracted a massive amount of attention. And indeed, in our office, we were only talking about this case in relation to an adjudication a couple of weeks ago. The parties here are Northern Ireland Housing, which is part of the government setup, and a company called Healthy Buildings. The parties here used an NEC 3 professional services contract. So again, this isn't the standard main contract or subcontract that many of you will be familiar with. And the work was all to do with the surveying for asbestos. The contract was dated 2012, and in January 2013, there was an instruction to carry out significantly more testing. That work was completed. Quotations were requested in August and October 2013, and indeed Healthy Buildings did provide that information within 10 days. Now, what I will point out at this point is that there was an instruction, then the work was completed, and then there was the request for quotations. That is absolutely not how NEC is supposed to work. It's supposed to be a foresighted, upfront contract. Well, clearly the parties didn't get the memo on that particular part. Those quotations were then provided, and Northern Ireland Housing clearly had their red pens out because they quite simply rejected the quotations and valued them at nil. It went to adjudication, and a decision was issued in January 2014. And actually, Healthy Buildings were very happy with that decision. It said that yes, this was a valid compensation event, and they then actually were paid out in relation to the particular extra work. Now, it is important at this point to look at what I think is probably the most important clause in an NEC contract. For ease here, I've quoted the main contract version, but of course the other NEC contracts in the suite of contracts have very similar clauses. 61.3 states the following: the contractor notifies the project manager of an event which has happened or which he expects to happen as a compensation event if the contractor believes that the event is a compensation event and the project manager has not notified the event to the contractor. If the contractor does not notify a compensation event within 8 weeks of becoming aware of the event, he is not entitled to a change in the prices, the completion date, or a key date, and this is the important bit for this case, unless the event arises from the project manager or the supervisor giving an instruction, issuing a certificate, changing an earlier decision, or correcting an assumption. So in other words, we have this list of compensation events, NEC 3, there's about 19 of them, and instantly you split the compensation events into two piles. Those for which the contractor must give a notice within 8 weeks, otherwise the contractor will lose its rights to claim a change in the prices or the completion date or a key date, and those for which it is not a condition precedent. Now, from the information I've already given you in relation to this particular case, we did here have an instruction to carry out more testing. So Northern Ireland Housing, however, argued that the consultant's claim for a compensation event was out of time because of this 8-week time bar. But of course, there is no time bar for claiming a compensation event which starts off as an instruction, and indeed that's what was held in the adjudication. In the High Court, the High Court agreed with the adjudicator that there was no time bar on instructions. And indeed, the Court of Appeal also agreed with that as well. The other part of this case was how the instruction should be valued. And really, what we've covered so far, I think pretty much everyone would agree that that was their understanding of the contract. The issue then revolved around clause 63.1. And I have to say, this clause is a bit of a head scratcher, particularly for those of you who are more familiar with ICC, ICE, or indeed JCT contracts. This clause said the changes to the prices are assessed as the effect of the compensation event upon. Now, remember, this is the professional services version. The actual time charge for the work already done and the forecast time charge for work not yet done. The date when the employer instructed or should have instructed the consultant to submit quotations divides the work already done from the work not yet done. Well, of course, here, the employer in this particular case gave the instruction for the extra testing in January 2013 before any of the additional testing was done. So, following a very strict reading of this clause, this should be valued only on a forecast time basis. That's what you would think. So the question to the courts was, should the work be valued on a forecast basis because that's what the contract says, or should it be valued on an actual basis using the available evidence? Because of course, by the time the quotations were given in August and October 2013, the work had already been done. So there are very unusual circumstances here that the quotation was only priced after the work was completed. It was held in relation to this particular question, rather surprisingly, that evidence from timesheets and other material of what the consultant actually did in that period, particularly with reference to the change in instructions, is not only relevant evidence, but clearly the best evidence to assist the court in calculating the compensation to which the consultant is entitled. So it could be argued here that the judge has read the contract. It does say it should be valued on a forecast basis, but the judge is saying, well, the best evidence for valuing this is on the actual basis, which is rather surprising. I do like this bit of the judgment. The judge in this case actually said, why should I shut my eyes and grope in the dark when the material is available to show what work they actually did and how much it cost them? I just think that's a fantastic phrase that's used there. And I can understand this from the judge's perspective. The information, the live or the actual information was there. So why would we jump into our TARDIS and go all the way back to January 2013 and try to forecast what was reasonable back then, bearing in mind the work was done before the quotations were given? So this does appear to go against the express terms of the contract, including clause 63.1. And the concern, I think, here is that employers, project managers, may well decide to delay notification or to delay assessment and actually then value the works on an actual basis. I will put a note of caution on this particular case. It is a Northern Ireland case, and therefore it's not binding on the English and Scottish courts, but it would certainly be persuasive. The key for me here is actually both parties went off piste, so to speak. So in other words, what they should have done is the employer should have given the instruction and asked for a quote at the same time, and the quotation should have been given before the work was done. So they'd already gone away from some of the contract terms. I think if this was to go in front of the English courts, in a normal situation, it would be distinguished on the basis that the instruction is given and the quotation is given normally before the work is done, and then we're back to a forecast basis. Okay, our third case for today, in fact, our third and fourth case today, is Imperial Chemical Industries and Merrill Technology, which I'm obviously shortening to ICI and MMT. A hugely interesting case, and I will say well worth a read, if only to show everybody this is not how anyone should be contracting. It does start off in a positive way. We do have a contract in place, the NEC main contract, the June 2005 edition, plus the amendments from 2006 and 2011. It was all about steelwork for a new paint factory. And this contract was put together and agreed in 2012. A relatively modest original contract value of 1.9 million. And that's about as friendly as we're going to get in this particular case. At the time of the case starting, MMT had been paid just short of 21 million, and they wanted 23 million. ICI, however, said it was worth 10 million, and they wanted the overpayment back. This case turned into an absolute nightmare. The employer terminated the contractor's employment on two grounds. There were defects in the work, and this was all about welding, and there was a failure to provide documentation. Looking at the first issue on the defects and the welding. So, looking at defects and quality, clause 11.2.5 defines a defect as a part of the works which is not in accordance with the works information. And clause 40.4 says if a test or inspection shows that any work has a defect, the contractor corrects the defect and the test or inspection is repeated. A post-tender meeting confirmed that the welds must be tested via a visual inspection and 10% dye penetration, but that importantly, there was no reference to radiography. Everyone agreed that radiography is a more expensive test and indeed is a more stringent test as well. The testing and inspection regime was approved by ICI before the welding did commence. And the question in this first part of the case was whether MMT were liable for all defective welds, even those which could only be detected by radiography, or it was limited defective welds. In other words, those which were only identified by the agreed procedure. So in other words, radiography would have been ignored. And it was held in this case, and MMT were very happy with this result, that they were only liable for defects in the welding that was identified by the original contractual testing method. And the court said here that the bargain struck between the parties could not be written at a later date. ICI had tried to argue that in this particular case, that MMT had repudiated the contract and indeed accepted that ICI had accepted that repudiation by terminating. The judge noted, however, that ICI's reliance on the defective welds was flawed. This was not a valid ground to argue that MMT had repudiated, nor was it a ground for termination. The second ground in relation to the termination was the failure by MMT to provide information. Now, the termination notice was actually issued by ICI on the 17th of February 2015. They earlier on that day at 20 to 3 had asked for information, and they'd asked for that information to be provided by 5 o'clock. And this was all to do with welders' tests certificates. And it was because MMT had failed to provide that information in 2 hours and 20 minutes that they then said that there was a breach. The court described that 2 hours 20 minutes as an unrealistically short time frame and clearly not a breach. And it was held in this case that ICI itself was in repudiatory breach of contract by instructing MMT to leave site. Because they were in repudiatory breach, MMT could claim a loss of profit on the works that had been instructed, but which they were no longer able to do. The third part of this case was all about the project manager. And at the start of the job, the project manager was a firm called Progen. Now, I know that everybody has their own view on whether the project manager is independent, and we had the same discussions under ICE and the engineer. We have the same discussions about JCT and the employer's agent or the architect or contract administrator. And this is interesting. So, originally, we have an independent project manager, a separate company called Progen. But what the employer did here was instructed the project manager not to make any assessment of amounts without the employer's agreement. Now, at best, that would be called a fetter on the project manager's power, but it's certainly significant interference. And I have to say fair play to Progen on this as the project manager, because they then resigned. ICI then appointed an employee of its parent company as the project manager. And the court said about this that the situation that the employer sought to impose was fundamentally different from that for which the contractor had appointed. They had contracted on the basis of an independent standalone project manager. The court said that no proper replacement appointment was made, and this purported appointment was actually a breach of contract. So, as you can see in that case, ICI went away with absolutely its tail between its legs. But clearly not enough, because we ended up in court on this case again in 2018. So it looks like I'm repeating the same slide. It is all about the same case, but there was a new court case in 2018 and it had different issues. It's the same project. We still had the £1.9 million original contract value and still the 21 million paid at the time of the case. And we still have this issue of the overpayment. And what the courts were looking at here is the possibility of revisiting assessments that were made. And the court said here that there was nothing in the NEC which said that a project manager's assessment was conclusive as to the rights of the parties. The court wasn't bound by earlier assessment which had been made by the project manager, although, importantly, they were of powerful evidential weight. Remember that Progen ended up being kicked off because the employer wanted to approve before the certification was made. The court also went on to say that there was no good reason at all to revisit the final agreements which were reached between the contractor and the project manager. Each of those agreements satisfied the requirements essentially for the formation of binding legal relations between the parties. Again, I think this is an interesting case to read because the judge did not take kindly at all to ICI's experts and actually said this, that the evidence of the employer's experts was not sufficiently independent. And then rather sarcastically, if that lack of independence was a coincidence, it was a remarkable one. And obviously we can all read between the lines. So remembering that the contractor had at this point been paid just short of 21 million, they were looking for about 23 million, but ICI was looking for that massive deduction. What was finally held here is that MMT were owed a further 270,000 plus VAT. Now, that was barely 1% more than the amount that had been awarded to the contractor in adjudication. And the judge actually said that this case stood as an advertisement for adjudication and essentially saying that the parties had been crazy to find themselves in several court cases on this particular issue. Let's move on to a different case. And now we're going to look at SSE Generation and Hochtief 2018. A huge, enormous case. The numbers here are eye-watering. We're looking here at an 8-kilometre tunnel from a reservoir at the head of Glentarf to Loch Ness, but unfortunately we have no mention of a monster in this case. Hochtief contracted to design and build a hydroelectric scheme under NEC 2 Option A, unsurprisingly with some amendments. The tunnel was taken over in December 2008 and the tunnel collapsed in April 2009, only 4 months after the work had been finished. Now, just note, this case didn't get to court till 2018. That's a hellish amount of time to have that black cloud hanging over these parties. Hochtief declined to carry out the remedial works, and SSE, the employer, engaged another contractor to carry out the works for £137 million. And the question, of course, was asked, who should pay? And this looked at the NEC 2 contract provisions. And that confirms that a collapse at a takeover was the employer's risk, unless it was due to a defect which was existing at takeover. And that's from clause 80.1. Again, what is a defect? Part of the works not in accordance with the works information, or part of the works designed by the contractor not in accordance with the applicable law, or with the contractor's design which had been accepted by the project manager. Now, within the works information, it said that the tunnel should have a design life of 75 years. And design life was interpreted to mean a reliable service without a requirement for a major refurbishment or significant capital expenditure. In the first court hearing, now we are in Scotland on this one, so the first instance court, they held that Hochtief were not to blame. I can just envisage that back in those days, there was an enormous party at that point. The defect was not in existence at the time of takeover. However, SSE, and bearing in mind the figures involved here, they decided to take it to appeal through the inner house of the Court of Session. They pointed out that there was a 2-year defect liability period to determine if the works were designed to a 75-year life. It wasn't a guarantee of 75 years, just that it was designed to last to that period. SSE proved that it hadn't been designed to provide a 75-year lifespan because they said, look, it collapsed within 4 months of handover. The court agreed that Hochtief's design was defective and they had to pay 108 million plus interest. But what was interesting here is that the judge's decision was split 2-1. There were 3 judges in the Court of Session inner house. Now, this issue of design liability, they looked at the design being approved by the project manager, that it included for areas, now excuse my pronunciation here, erodobile rock to be shotcreted. And there was actually no shotcreting in the areas of erodobile rock that was found. So it wasn't really about whether the design was defective or not. It was quite simply that Hochtief hadn't carried out works in line with their own approved design. They should have carried out this shotcreting. The shotcreting had been approved, but they hadn't done it. And that was therefore deemed a defect. It was held that the collapse of a tunnel was due to the absence of shotcrete. It was a failure in the implementation of the works, not a failure in the design itself. Hochtief were liable for the cost of repair. Option M, therefore, was not applicable. They didn't look at whether reasonable skill and care applied or not. This was all about the fact that they hadn't done what it said on the tin of the installation. We move from a huge, enormous 140 odd million pound dispute to a tiling dispute between Mr. and Mrs. Feingold. So Mr. and Mrs. Feingold here are the employer, and the tiling firm was Cytol. You couldn't get a bigger contrast in the size of these two cases. There was a bit of a difficulty here. There was also a third firm, Proman. They might have been the main contractor, or they might have just been the project manager to the employer. Mr. and Mrs. Feingold were not particularly happy with the works, etc. Feingold weren't happy that they weren't being paid, and this particular dispute went to adjudication. The figures here are staggering, but it is still only a relatively small dispute. The adjudicator held that Feingold had to pay Cytol £86,000. That was roughly made up of £45,000 for the dispute and adjudicators' fees of £42,000. This was an NEC short contract. And it involved contractual adjudication, not statutory adjudication. As we saw from an earlier case, you can only go to arbitration if you have been to adjudication first. And again, we are signposted to 93.3, which I read out before. A party may refer a dispute to the adjudicator if the party notified the other party of a dispute within 4 weeks of becoming aware of it. If a disputed matter is not notified and referred within the time set out in this contract, neither party may subsequently refer it to the adjudicator or the tribunal. There were 3 questions asked when this case got to court. Sorry, two questions that were asked. Who Cytol had entered the contract with, and whether the adjudication had been commenced too late. Now, this issue of who they'd entered into the contract with was very important because at this point, Proman were insolvent. Cytol, the tiling firm, won the first part of the argument, that they were in contract with Mr. and Mrs. Feingold. But unfortunately, they lost the second part. The adjudication had been commenced too late. Even the judge in this particular case couldn't decide on the date the dispute arose. It was either the 19th of February or the 19th of March. But importantly, actually, that wasn't too important because Cytol didn't start the adjudication until the 25th of April. And so on either date, it was outside that 4-week period. And therefore, the adjudication was not enforced. So thinking of the numbers, Cytol then had lost the 45,000 that they would otherwise have been entitled to. There was the cost of the adjudicator, a further 42,000. And now because this case went to court and they lost, they would have had Feingold's legal costs and their own legal costs to pay as well. And it all goes back to this issue of formation of contract and understanding clauses such as 93.3. We move forward to, again, 2019, and we have here the case of Doosan and Interserve. Again, of course, we're on an NEC contract, but this time it's an option C. Now, of course, option C is described as a target cost. I prefer the phrase cost reimbursable with a twist. And of course, that twist is the pain gain calculation. It was a little bit more complicated, this, because the two parties here, Doosan and Interserve, were actually in a contractual joint venture on Horsley water treatment works. Together, they submitted consolidated interim applications under the main contract, and monies were then drawn down to each party. However, partway through, Interserve refused to sign off the release of funds to Doosan because they became aware that they were going to be in pain rather than gain when it came to that calculation. And Doosan were not very happy about this, so they decided to seek summary judgment because obviously they wanted their cash in their bank at the earliest possible opportunity. It was held in this case that Doosan had breached the joint venture agreement by refusing to authorise the payment, and Doosan was entitled to a payment of 5.3 million. The court looked at the provisions about when you do the pain gain twist. And the court concluded, I won't read out all of the phrases there, the court concluded that it was clear that you only do the pain gain calculation at the end, after completion of the works, and not on an interim basis. The court said there is no other provision for the assessment of the contractor's share at any earlier stage. So very, very important issue there in relation to cash flow. Moving into 2020, and we have Van Ord and Dragados. And again, this is kind of showing how the NEC takes normal contractual provisions and what we thought we understand generally, but then you view it in an NEC context, and it does look rather different. It's another Scottish case. This is a harbour expansion project in Aberdeen. The main contractor here is Dragados, and the subcontractor is Van Ord, and it's all about dredging. The subcontract between the parties was an NEC option B, so it's a remeasure. And Dragados, in a very naughty way, omitted works from Van Ord's subcontract and gave it to other subcontractors. And I'm sure I can hear somebody shouting, breach, at this point, and I absolutely agree. This, to me, is a straightforward breach of contract. In court, the parties did refer back to, I'm going to say, a pretty famous case called Abbey Developments and PP Brickwork. And again, just to read out the first bit here, a contract for the execution of work confers on the contractor not only a duty to carry out the work, but a corresponding right to complete the work which it contracted to carry out. Importantly here, essentially, they are saying that this would be a breach of contract. And indeed, in this particular case, the court agreed that this was a breach of contract, but it was also a valid instruction under the subcontract. And the courts pointed out that this was not an unusual set of events. Compensation events under an NEC contract often arose from a breach of contract. The instruction here was a compensation event, and importantly, it should be assessed accordingly. So, in other words, using defined cost. The court considered that this wasn't unfair. There was an adequate mechanism in the contract to compensate the contractor for emissions, and therefore, in their view, the subcontractor was not better or worse off. I'm not quite sure that I entirely agree with that, because this does seem to be trampling all over sanctity of contract and this right and obligation to do the work. I bet Dragados would not have been happy if Van Ord had turned around to them and said, actually, I don't fancy doing this piece of work because I'm not going to make much money out of it. And yet that's exactly what Dragados have done by saying to Van Ord, we can get someone else to do it cheaper than you. And I think there should still be a sanction in place, but not on this particular case. We have two more to have a look at, and they are both 2021 cases. The first one is Transport for Greater Manchester and Kia, a very recent case. Again, this is an NEC 3 contract, but this one is the NEC main contract. and it was for a bus interchange in Bolton. In this particular case, an adjudicator's decision was issued on the 25th of November 2019, and our notice of dissatisfaction was issued on the 29th of November 2019. Kia, however, claimed that the notice of dissatisfaction was invalid. It was not sent to Kia, but it was sent to their solicitor representatives. The court looked at a number of contractual provisions. They looked at W2.42, which says a dispute may not be referred to the tribunal, remember litigation or arbitration, unless this notification is given within 4 weeks of the notification of the adjudicator's decision. They also looked at 13.2. A communication has effect when it is received at the last address notified by the recipient for receiving communications, or if none is notified, at the address of the recipient stated in the contract data. Finally, 13.7. A notification which this contract requires is communicated separately from other communications. So we go back. What did the contract data state? Well, the contract data clearly stated Transport for Greater Manchester's address at Piccadilly Place and Kia's address at Tempsford Hall in Bedfordshire. However, the works information at clause 920 said communication shall be undertaken using the Project Extranet NEC3 change management tool provided by Conject. Importantly, though, here, Kia had subsequently confirmed that it would be represented by a solicitor in the adjudication and gave the solicitor's details. The notice of dissatisfaction of the 29th of November, 2019, essentially went between the two solicitors, and it was in 3 paragraphs. The first paragraph said that the adjudicator essentially had got it wrong, erred in law and in his interpretation and application of the express terms of the contract. The second paragraph asked Kia to raise an invoice for the sums awarded, and then also asked if the solicitor for Kia could accept service of formal proceedings. The court decided in this case that the parties had complied with 13.2. They'd used their solicitor's address, but they'd notified the other party that that could be used. The 13.7 argument, should this communication have been notified separately, the judge here said, this letter is short. The first paragraph said, we dispute the decision. That second paragraph that they intended to refer it to court, and the third one said that they would asked whether they would accept service of formal proceedings. The reference to the invoice didn't amount to a separate notification. It arose out of the decision, and it was simply confirmation that despite the notice of dissatisfaction, the adjudication decision would be honoured, and therefore the notice of dissatisfaction was valid, so the adjudicator's decision was not final and binding. So this could be a case that we might see in future seminars. 2 more cases to go through. Croda and Optimus, again, 2021. We have another professional services contract here. It's a job in Hull. Unusually here, this is a W1 situation, and it was a dispute over the value of services provided. So we haven't got statutory adjudication, we have contractual adjudication. It went to adjudication, and the adjudicator decided that Optimus had to pay Croda 343,000, that was a negative valuation. But the adjudicator decided he did not have the power to order a repayment, so it went to a second adjudication. And this then ended up in court. The court decided here that by looking at a combination of W1 and W2, that the adjudicator did have the power to decide that a negative interim payment was required to be paid. And yet again, we see this issue about once an adjudicator's decision is issued, you only have 4 weeks to take it to the tribunal. And the court in this case again said because there'd been no notice to go to arbitration or litigation, that decision was final and binding. The last case we have at 5 minutes to go. Fraserburgh Harbour Commissioners are McLaughlin and Harvey, 2021. Yet again, we are back up in Scotland. Another NEC 3 ECC June 2005 case. And this particular one, Fraserburgh began court proceedings regarding alleged defects in the project. McLaughlin and Harvey said, sorry, mate, you're in the wrong forum. You've started court proceedings, but what you should have done is go to adjudication. And in any event, the tribunal is arbitration. The court in this case looked in detail at W2.4, again, which is all about you can only go to the tribunal if you've been to adjudication first. And I've reproduced there 2.4. The judge in this case, Lady Wolfe, agreed entirely with McLaughlin and Harvey. Fraserburgh had started proceedings in the wrong forum, and the court proceedings were therefore halted. If they wanted to continue with the dispute, they would have to go to adjudication first and then to arbitration, unless, of course, the parties agreed otherwise. And with 4 minutes to spare, I can now ask Gemma, and I think we'll have at least one. Do we have any questions, Gemma? We do. She's brought this one up. Thank you, Chris. Right, we are looking here at 61.3. I am just flicking back to my notes because this goes all the way back to the start. Chris's question is, if you remove from 61.3 the words after unless, so unless the event arises from the project manager or the supervisor giving a decision, giving an instruction, issuing a certificate, etc., and the project manager doesn't raise a compensation event at the same time, could this then be time barred? My view, Chris, is a resounding yes to your question, that absolutely this would mean that the contractor must then notify every single compensation event. I think I'd probably have a play with, 61.1. And if I was being really mean, you can see that in 61.3, it's an 8-week period. I think I'd probably be tweaking that as well. Okay, so yes, Chris, you have raised a brilliant point here. If 61.3 and perhaps 61.1 are amended, in that case, yes, the Northern Highland housing case, I think, would have been decided in a different way because healthy buildings would have been out of time. Excellent. Thank you, Chris. Gemma, I'm continuing to bite my nails at this point. Gemma had forgotten to write the words easy in her question. If anyone's got any additional easy questions, please do put them in the chat box. Any difficult ones can be saved for sending to me personally, so I don't get embarrassed on this session.
You may have an easy session today, Geraldine.
I know, it's looking very, very good. I'm trying to see if I can find a button, Gemma, that stops the chat, but I can't find one. I will flick on here to my last slide and say, if you do have ones that you haven't managed to type, you've got my email address there. I would be delighted to take any questions you've got on these cases that I've been swatting up over for the last 24 hours in a bit of a panic. Please do link with me on LinkedIn or follow me on Twitter as well. Yeah, and that's it from me. I'm delighted. I can't see anyone else typing.
Well, thank you very much. Thank you, Geraldine. Another really interesting webinar. Thank you. Thank you to everyone for attending. As normal with these webinars, Geraldine is happy to send out a PDF of the slides afterwards. So we'll get those sent out to you. Oh, I started panicking then, but it was a thank you. So that's
me too, Gemma.
So yeah, we'll get a copy of the slides out. As you know, we also record these webinars. So for everyone who's attempted, we will also send across a link to the recorded webinar. So thank you very much to Geraldine. For anyone who does want to stay on just for a minute, we've had one late question in. Ryan has been holding this one in, obviously, ready to go. So I'll just bring this up for you, Geraldine, if that's okay.
Oh, right, let me read this. Okay. If an auditor makes an assessment and includes a big withholding, and there's a period of time to attempt to negotiate this with the employer or project manager, are you still time barred by 4 weeks to take it to adjudication? Right, couple of things to say on that, Ryan. The first one is that this time bar between the dispute and starting adjudication, right? So it's important, there's couple of different time bars here. Between the dispute arising and starting adjudication, that particular one is peculiar to contracts where the Construction Act doesn't apply. Okay, and so the Cytol and Feingold case, and I think the first one, which was the Costain and Tarmac case, one was a supply only, one was with a residential occupier. So in that particular case, let's say if it happened in Cytol or it happened in Costain where the Construction Act doesn't apply, yes, the interruption by the auditor, I think in that particular case, you are still time barred by the 4 weeks. That's the first thing to say. If we look at this underneath the ambit of the Construction Act, then actually the 4 week time period between the dispute arising and starting an adjudication, that doesn't occur there. Where that does occur is between adjudication and going to the tribunal. Okay, so what you need to do first in relation to your question is decide, a bit like the hokey cokey, are you in or are you out of the Construction Act? And how does that 93.3 fit in, if it does exist in your contract or not? Okay, yeah, I mean, this issue about the auditor, I can't see that the auditor from one side or the other would actually stop the contractual proceedings at all if you're outside the Construction Act. Fingers crossed,
Okay.
I have answered your question.
I think
If
that's
not,
it.
oh God, Ryan, if I haven't, do by all means give me a buzz. Not a problem.
Great stuff. Thank you so much, Geraldine, and thank you to everyone for attending. As we said, we'll get a copy of the slides sent over to you, and we'll also get a copy of the recording. So if there's any of your colleagues who you think would be interested, feel free to pass that on to them. And also, everyone who's attended today should get an automatic invitation sent to you for the next webinar, which will be taking place in June, I believe. So hopefully we will see you all again very soon. Take care, everyone. Stay safe. And yeah, we'll see you at our next webinar. Thank you very much.
Thanks, Gemma. Cheers.
Thank you, everyone. Bye.
Bye-bye.